Okay, you were all set.
All right, so we have sound?
You do?
All right, awesome. So today, we're gonna open the meeting. So I'd like someone to motion to open the meeting.
I will motion to open the meeting.
Second, vote. Aye, okay. So the village board updates. Are there any village board updates, Tim? Nothing? Okay, cool. Are there any planning, zoning, code enforcement updates?
Just the regular reminder for training credits. You have to
Okay.
do 4 by the end of the year.
Okay, great. Okay. So now we'd like the new application to come up for the area side yard setback. That would be 160. You're gonna have to come up. Tell us what you want to do.
Just for the public, the chair decided to change the agenda to this gentleman first.
So, have you done this before?
I have done it here.
Okay. Okay, so this is just lets to know what's going on, and then the next time it's a public hearing
Right.
about it.
Yes.
And we voted on it, so you're about 3 months to get everything through. Or
Yeah.
like 2 months.
Yeah, I hope that tonight you'll agree to set a meeting for next month.
Yeah, that'll tell you. Okay, good. All right, so just let us know what you want to do.
Okay, this is a residential addition, 160 Huguenot Street. I have some pictures of the house, if you'd like to take a look, well, if you get yourself. I designed this, I'm an architect for Northeast Architecture in Highland, New York. I designed this house about 20 years ago. Well, I should say redesigned it. It was a very plain house, and the owners, they wanted just basically, they wanted a design that would give them a family room, because they have grandchildren now. And they wanted something that would blend in and balance the facade. And you can see on the Henry Court side, it looks like a big grass area, but about 12 feet of that is, I guess, village right away or something like that. Anyway, so the logical place to put it was on the south end, on the Henry Court side. If we put a 12-foot addition, we are going to be a couple of feet over the side setback. So we're applying for a variance on the side. We would like to have a 17-foot side yard. I can show you site plan and the elevations for.
You want 17, you
Well,
want
there's-
17 foot of variance?
No. We want a 3-foot variance.
Okay.
We would like to have a 17-foot clearance to the side.
Right.
Is the code 20?
Go to 20.
Okay.
Yes.
Okay, can you show us
Okay, so, this is the site plan. And next page would be the elderly.
Yeah, we gotta make that small. Okay,
So it's a Henry Court side right there at the bottom of the site plan.
so you're not even, so the building, the proposed family room is only, how big, what's the actual size of it? It's 12 foot by
12 foot by 26.
26. Oh, so it's the whole length of the house.
So yes,
Hold up, yeah.
width of it, yeah.
Is it cut in a little bit there?
It's just a couple of inches cut in because it's a brick house. They have to leave the corner of the brick there.
I hate how that looks. That's so.
Well, it's blended in. If you look at the next page, it's blended in with the porch. So there's not gonna be an aesthetic problem because the house has a front porch. Yeah, the house has a front porch and we're extending the front porch and wrapping it around the corner. I think it is, thank you.
Yeah, that's, okay, that makes me, I just hate those jogs at the end.
Yeah, it'll be covered underneath the porch. I don't think it'll be.
Just for the board's knowledge, this also has to go to both the planning board and the design review. Because it's in the historic district,
Right.
so just so you're aware of, it is also going to both of those. You're just the first board to see it at this point.
No, there is a. Are you taking out the chimney?
No, the chimney is gonna stay. It's really not affected. It'll be inside the family room.
You're gonna have the doors here, if the chimney's.
There's doors on either side of the chimney.
Okay, that's not the scale of it. The chimney's not 3 feet wide.
Let me take that one. I'm not sure what question that's over. That is the,
3 inches, 3
That
and a
is-
half inches.
that is the back, that is the front side of the house. That's the front side. So on the left side is the chimney. I can come around and show you. Yeah.
So chimney on the picture, there's a chimney in the.
Oh, this is the house.
This is the
This
porch.
is just the addition. I was.
This
just
is the-
Oh, okay, I'm sorry. Okay, so this is the chimney right here,
Yeah.
right there. Oh,
This is
oh,
the-
okay.
Yeah, this is it.
All right.
That's the zoomed in. I didn't catch that either.
Yeah, okay,
Yeah, so that's and then the doors are.
okay, that's fine. Yeah. It looks, but this is not your, ooh, spray foam, love spray foam. It's hurricane clips too, fancy.
And the 20 foot,
The 20 foot would give them like 9.5 feet inside or 9'3" inside. It's a family room. you know,
yeah,
It's not gonna work.
Yeah, and the chimney is probably making me see.
But they like, they wanna, there's a fireplace inside. They wanna keep it as part of this. They really love this house and they don't really wanna change the character of it. So a lot of things are like the chimney, well, the chimney's serving the fireplace and the furnace downstairs.
It is, okay. Do you guys want to see this? I can see it.
so there's 30 foot. Of. City clearance in addition to that 20. From the edge of the road,
So,
because the property line starts 30 foot setback.
oh, this is,
So this is actually going to be 47 foot from the edge of the road as it sits.
so there's a lot of, how much of the property is the town?
It's like 15 feet, 12, 15
So
feet.
from the edge of the road, 15 feet in?
Yeah, there's lawn. So when you first look and you can see in the pictures,
Yeah, it looks like a
lot of
massive
space.
lawn,
But when you look at the survey, it's like,
This is.
so I think that mitigates it to some extent
yeah.
as far as.
Because you're still 30, it looks like you're 30 feet away from the edge of the road, even though, okay.
Well, to the property. line. With that 17s and stuff, yeah, the scales.
Okay,
Well, that's
Oh,
the,
30 foot from there, okay, so 12 or 13 foot. Yeah,
okay, so
well,
what's this,
let me come around.
Right, right.
I'll take a look. Which one?
so what's this measurement right here, from here to here?
should be 13 foot.
Okay, yeah, that is, right, that 30 feet is to basically the edge of the pavement
From
from the house, in the addition to the.
So that would be, so this is 30 feet, if
It's
you're
just,
taking,
yeah, right.
if you're taking 20 feet off of that, well, how big is this from here, 17 feet?
Yeah. There's your seven, there's the problem.
So
Here's
it's
the
like
actual
13
property
feet.
line.
Yeah.
And here's the addition, so this is the problem right here. In fact, this dashed line is the setback line.
Right, which is, so this is 2'8" and.
Yeah, so you're not asking for, you're asking for,
For 2 foot,
Yeah.
no, you're not
so
asking,
3 foot actually.
no, you have to be 16 feet off the property line, the property line's here. So you're asking for you're asking for,
Yeah, it should be 20 foot up.
Right, the town,
And
it's only
with
requires
the
20.
addition, this is the proposed addition, so it will be 17. This 13 to.
Yeah, the requirement is 20 from the property line and
This is the property line, so it's 20 from there. And this is the proposed addition, so it's 3 over the property. line.
right, we're requesting 3 feet.
3 feet. But from here to the building is 30 feet.
Give or take, yeah.
If you were to add space to the back, it would require a variance as well.
It would go, yeah, there's, already it doesn't have enough room to edit in the back. So that would be, in fact, the whole thing, I think, would be, the entire area would be in a variance if you had it at the back.
Yeah,
But this would just have.
unless it was where the current patio is.
Yeah. I mean, this is the only,
That makes me feel a little bit about
this is my question, where's the property line?
it. That line.
So they're gonna,
The square,
what's this dotted line?
the setback there required.
Okay,
And so this is the proposed,
gotcha, okay.
Yeah.
All right, thanks for.
so right now they are 9 foot inside of where they could build.
Yeah, okay, all right. That's pretty clear, you need 3 feet. Okay. Well, and you have a lot of, it seems like you have a lot of room. Because of, not just because the town holds a bunch of it. All right, cool, okay.
Okay.
Do you guys have any questions or anything to add? All clear? All clear? We're good? Okay.
Okay.
So you're gonna have to,
We get a hearing next month?
yes, we'll get a hearing, we'll get you a hearing. Okay. You're gonna need to tell the neighbors. And
Have
send,
we noticed the neighbors or the town does?
You do, I'll be sending you the information.
Okay, okay.
You got it, have to do it 10 days before the public hearing.
yeah, we're gonna. Yeah, okay.
David, with this being planning board as well.
Do you want that or you want to give that back?
I don't know.
We're type two.
Okay,
Planning board,
planning board will be meeting, next meeting,
let me look it up, but I think an individual
Okay.
residential
uncoordinated.
setback is, we're just out of it, we're just type two.
Okay,
So planning board can do what they want.
all right, so we're gonna set a public hearing. Do, Mike, do you need
Yes.
these plans?
I have the plans, but may I keep the pictures and put that
Yeah,
as part of the
sure.
record?
Okay.
Those are all copies of the same.
Just,
Oh,
all
Yeah, there's like a few.
right,
Yeah, I just need one set.
Okay.
okay, all right, so
If
we're
you
going.
want-
Okay, thank you very much.
Hearing and
I'll see you next
all the
month.
stuff and we'll do the next week. I'm not seeing a huge issue here.
Okay, great.
Okay,
Just make sure to follow that because it.
Yeah, I'll be sending you the information by Monday, and you just have to post it by 10 days before the meeting. Before the hearing, so.
We'll do. Okay, thank you.
No, I do that and so I'd like to set a motion to have a public hearing for 160 Duganite Street, October 8th.
Yeah.
Okay, good. Vote? Aye? Okay, good. So we're done.
Who seconded, I'm sorry.
I said, he's seconded it. No.
Yes.
Okay. All right, so, I think so. We're good with that, right?
You are good.
Okay, cool. All right. Okay, so, we are going to now talk about 7 Prospect Street. Before we open up the public hearing, we're gonna have, 2 of the board members talk a little bit about what some of the laws. And then we're gonna open the public hearing and then we're gonna have Sherry come in and present and then we'll move on from there. Okay? So Ian, you wanna talk about what you found out?
Sure, yeah, so we have some of the definitions according to New Paltz as well as local and non-local municipalities about rooming house. So according to New Paltz, dwelling unit occupied by a resident owner or agent thereof and his family. And from whom 4 or more tenants rent sleeping space without provisions for meals. So I also got a definition here for the resident owner, according to New Paltz. The village of New Paltz is the owner of a dwelling for whom said dwelling constitutes his or her legal residence and their primary place of occupancy. Being the place where the owner physically resides for the majority of the calendar year. And who shall be responsible for including but not limited to emergency situations. And the maintenance, repair and daily management of said dwelling. In accordance with the code of Village of New Paltz and the laws of the state of New York. So I've also fetched the definition of a rooming house according to New York State. In the New York State Multiple Dwellings Law in section 4. The owner of a dwelling for whom said dwelling, oh, I'm sorry. Right. So the features that it adds to New Paltz's definition, that definition being a bit vague. Is a home that rents out individual rooms to multiple tenants, usually sharing amenities like kitchen, bathroom. Usually having limits and minimums on the number of allowed tenants based on square footage. Municipal limits are commonly minimum of 4, maximum of 30. Usually require licensing by the municipality. Non-self-contained apartments. And accommodate both short and long-term leases, and usually will have individual leases for tenants. So those features will constitute a rooming house as far as New Paltz is concerned.
Okay, all right. Robert?
So I guess, some of stating some question is just how are we? Who's tasked with enforcement? I mean, does our code enforcement officer go out and ask people what their relationship is with whoever they're living with in a particular apartment? And I think that opens up a whole can of worms and, I guess be concerned about, but So, you know, part of it is getting an understanding of that, and I know you have this the definition of family, in the case law. You know, I just, you know, I see issues if we're out there and we're asking, you know, what the relationships of people in homes are.
Okay, so the village board has basically said that the building inspector, who's technically a law enforcement agent, can't go and look through windows and see who's sleeping with who and who's eating with who. So because of that, it becomes really difficult to decide what a family is. This is a village board policy that we don't have any control over. So before we open up the public hearing, we just would like to mention that if you're upset that people are living together and they're not family, that the people to talk to about that would be the village board who've set the policy that we can't do that. To me, it'd be pretty terrifying if law enforcement started sniffing around people's houses, looking through windows to see who was sleeping with each other. That to me sounds awful. If you disagree with me, that's okay. It's not my decision. That's the village board's decision. And if you're upset about that and you want our police and our inspectors to look through people's houses, the correct venue to do that is there. It's not here. Okay, you just heard what defines a boarding house, right? Or was that
Rooming house.
rooming house? And
Technical
the
difference.
technical difference between a rooming house, and one of them is that the person who owns a rooming house lives there. And Sam does not live there. So I just wanted to clarify that.
Or I'll point out according to the false code, agent or.
Yeah, so, and I don't, okay. So that's where we are, okay? I just wanted to talk about those two things. So now I'd like to motion that the public hearing start.
Motion.
Second, vote. Aye, okay, we're all in favor, so whoever would like to talk, please talk.
You can grab a sign sheet. So we have 4 names signed up, Bruce Gonzalez and Nash.
You can sit or go to the podium, you can sit, we're really short, it's fine, yeah, you can sit. Unless you want to leave the podium. No, okay.
I missed part of the New York State definition. Did the person have to live, did the owner have to live in the rooming house or just renting by the room?
So it does use the same definition of the resident owner and it requires that a resident owner be on the property as their primary residence for the majority of the calendar year.
Okay, so I mean, I have a whole statement here and I'm not sure what to do at this point. I want to say that if there was a resident owner, there would be way fewer problems. The problem we have with renting by the room is that there's nobody in charge. And when things are not working well, there's nobody to go to. So a rooming house, as defined by the state and the village, is actually more protective of the neighborhood than just renting by the room. And as far as peeking in windows, that there's no need for that. We live in a neighborhood on Prospect Street where we know our neighbors. I live next door to 7 Prospect. And I know that they're renting by the room. I've spoken to the tenants, to the students who are living there now. When the first student moved in, I asked him, he was there with his mother, kind of moving their stuff in. I asked if I could help. I said, oh, and who are the other people living here? And he said, no, I haven't met them yet. The previous, since Mr. Serta has owned it, there've always been rentals by the room. So at this point, when he put in an application to expand what can be proven is a rooming house or a rentals by the room, nobody has to peek in windows. I have signed a paper and notarized it saying I've spoken to many of the tenants and I know that they're renting by the room because they've told me.
Let's ask a question if I might.
Yeah.
Oh,
Oh,
I'm sorry,
you can't?
no, this is a,
Okay, fine.
this is a, sorry, that's just
All right.
how, yeah, that's just how public comment.
Was I
is.
not clear? I
No.
Okay.
it's- you-
And so I wanted to, I'm gonna talk about the definition of family because you talked about enforcing, but I'm gonna talk about the, New York State, legal definition LUO 5. And I'm just gonna read what I wrote here. States that any successful, Village Code defers to New York State case law for the definition of family. At the outset, New York State Legal Memorandum LUO 5 states that any successful zoning scheme which purports to create and attain a single or two-family zoning district must contain a definition of family. Then the memorandum reviews case law and summarizes a definition that are inclusive of non-traditional families, which is good, but still preserve stable family zoning districts. It concludes by presenting case law that defines the factual and functional equivalent of a traditional family of unrelated persons. Temporary rentals by the room for a period of a year was not considered to be a factual and functional equivalent of a family. Specifically, in the case of the City of White Plains versus Ferioli, a functional equivalent, and this is a family, and this is a quote, was not a temporary living arrangement as would be a group of college students sharing a house. So that case law said family is not a group of college students. That means a group of, if you have a group of college students, that is not family. And that's New York case law. And you don't have to peek in windows. You can get statements from the neighbors. All my windows are on that house. And so I've seen people coming and going. I've seen them move out at the end of semester. The new people move in. And they have told me that they rent by the room. So that's New York State case law. And additionally, despite the already too large scale of the project, which is out of character with the other properties on Prospect Street, the developer did not adhere to the approved site plan and made the project even larger. The larger than approved addition went up the week I was away from home. When I returned, I immediately notified the code enforcer, but received no response. So I'll just say it's disheartening for people who live in the village, who have make the village their home, care very much about our neighborhood and the village, to have spent so much time at meetings providing on the ground information about our neighborhood, only to see a non-compliant use expanded, one that was already problematic for the neighbors. That's it.
Thank you.
Thank you very much. Okay, our next speaker signed up is Terry Dogan.
All right, Terry, aren't you gonna talk to us? We're gonna talk to you a lot.
This is.
So you wanna do the public hearing and also do the.
The first thing is, in relation to your introduction about policy and so on. Once you have been appointed to the board, you are autonomous. The board of trustees no longer has any control over what you do and say. You're responsible to the law and only the law. State law first and also village law. The board's opinion is irrelevant once they have appointed you. And in terms of what the law says, that's what you have to follow. They can have their opinion. It might direct the way that they will act and consider things, but you, sitting here at this board, must follow the law. And when it comes to family, the pretty much definitive thing from the state is the legal memorandum, LUO 5, in the board mayor's statement that was mentioned. And that is the go-to document to look at for family. And in LUO 5, the most definitive part that there is, LUO 5 does not define family. LUO 5 talks about case law primarily. And the most definitive thing is a particular case is the city of White Plains versus Fariola, in which the court was making a decision as to whether a registered group home qualified as a family and could occupy a family zoning district. And when they talked about, they ruled that the villages or the city's definition of family was unconstitutional. But what they did say, they said 4 things regarding what a family is. The 2 things that are relative to us are: 1, a family is stable. It is a stable unit. That was the second thing in their discussion. And their third point was a family is not a temporary living arrangement, as would be a group of college students sharing a house. In terms of number 7 Prospect Street, the tenants this year are completely different than the tenants who were there last year. This is not a stable housing situation. The tenants who were there last year were there for 10 months. So they did not even stay for the full year. A family is stable. A group of students in a house is not. And it's 2 completely different families, and it is a serious error to try and confuse them. So what I would recommend is that you call the NICOM General Counsel and have a discussion with him. You need an objective legal person to talk to. Because right now, you appear to be under a serious misconception. And what that is a problem, because if it can be shown that the board acted unlawfully with prejudice, that would go really strongly against your decision. Generally, because you're volunteers, the law is very considerate and protective of you. And the fact that you volunteer to serve your community means a lot. However, when a situation where it is shown that the board acted with prejudice, the courts will forget that, and they get very strongly about it. It is one of the few times that the court will allow a cash judgment against a zoning board. Normally, there are a lot of times where a court might rule against the board, but they will not allow a cash judgment, except in case of prejudice. And I forget what the other one is too, just two. So you have to really be careful about how you're handling this. And the other thing, you're the zoning board of appeals, you have a lot of authority for that. Your authority that nobody else has. And when somebody goes before the planning board has no power to modify or waive the law.
We can give them all, yeah.
Okay. So what that means is that a planning board must obey the law without fail. And they can never approve something which is not entirely legal. In fact, they can't even vote on it. The law, as it's written, does not commit them to vote on anything which is not code compliant. And the problem is right now, the planning board is reviewing 7 Prospect Street. There are aspects of the
So,
matter.
Barry, can I just say something really quickly before we go on for about a while? I have about 10 questions I'd like to ask you, but I can't ask them during the public hearing.
Right.
So this is probably the wrong time to be talking about this stuff, because you're gonna come up later and talk as much as you want. We're not gonna cut you off.
That's okay.
But you've already said a bunch of things that I disagree with. Okay, you've also insulted the board, which is your prerogative. Okay, that's fine. You've also threatened us with lawsuits and losing money, and we can't respond to that right now. I would have responded to a lot of things. So if you want to continue to talk, realize we're listening, but you're saying a lot of things that we absolutely disagree with, and we're not gonna be able to talk about it later because you've already said it. So I would suggest that you realize that since we can't talk to you right now, you're not really, we disagree with a lot of things you're saying. Okay, and I've counted about 5 or 6 times that I've wanted to be like, that's not true. Liar, liar, pants on fire. And if you keep talking right now, we're not gonna be able to rewind the tape and go through it again. So you're gonna have to end up repeating everything you're saying all over again. And there's people behind you, and we would like to do this, and we're gonna give you as much time as you want to speak. But you've just given us a new document that we didn't get to look at, so it would probably be better if we did it when we can talk to you.
Bring up, I'll let somebody else.
Yeah, thank you, I appreciate that.
The next person on the list is Chino Wheeler.
Hello,
Hello.
I'll be brief. June Wheeler at 15 Prospect Street. I know there'll be probably some measurement issues brought up later. I can't speak to those because I haven't personally measured anything. I can see. So I do know that they built something that wasn't approved. They also, by the way, we were told, they said that no large trees would be felled. And I don't know whether tree removal was actually on the site plan to be approved, that was approved or not, but they took down at least one large tree. I have a picture of the stump of it, it's at least a 14 or 15 inch diameter tree, so I could provide you with that. Okay, but my 2 points about the zoning, the non-compliant use, that's been expanded, which I think that's against your codes. I live close enough, I live, right, on the other side of the Nash property. So I live close enough to observe the comings and goings of the occupants of 7 Prospect, whether from the front of the house when I walk my dog, or from my backyard straight across the Nash residents' backyard. So I can't speak to whether any families, by any definition, have been occupying 7 Prospect for the last couple of years, and they have not. Instead, the house has had a new group of people living there each school year that has been part of the Certus Prospect Estates. The most recent group last year consisted of 6 young men of similar ages and athletic builds. Now, maybe they were the family of sextuplets. I think we would have heard about that. They entertained themselves and their friends every Friday afternoon last spring by pulling a table out onto the driveway and playing noisy drinking games until past dark, so we knew that they were there. They moved out at the end of May like previous families had done. So it was, that house has never been since the Certus have owned it, has not been a single family house as a zone. So it shouldn't have been allowed to be added to. 2, my other support for the idea that these are rentals by the room is if you go to the New Paltz, New York Housing, Real Estate and Rentals, there's a group on Facebook, that's the title. You can search Sam Prospect, or you can just notice that there are frequent offerings. Things like back in July, there was a 6-bedroom, 2-bathroom house on Prospect Street, walking distance to campus. That was the description. It was for rent, that whole house, for $750 plus utilities. Good deal, right? I believe that was the asking price per room, because that is how they rent their rooms out. Okay, so my neighbors and I live in an R2 district. We very much appreciate that with lots limited to 1 and 2 family houses. We get to know our neighbors well and we trust them. We do have a neighborhood in every best sense of the word, and it is an invaluable asset to our lives in New Paltz. Why is it that R2 zoning designation? Why is that R2 zoning designation not being used the way it surely was intended to protect the character of any particular neighborhood that is so zoned? That's my question. Thank you so much.
Thank you. Would you like to submit that?
It's a little bit, yeah, I can make it better.
If
Just
you
want
want,
my notes.
you could email it.
I
to me.
don't mind you having it with my notes.
You could email it if you'd like, but, okay,
Is that?
that's fine. Thank you. The last person signed up is, Peter, is it? Peter Boyd?
Yeah. Pete Bayer.
Bayer with an A, my apologies. I thought it was an L, sorry.
No. So, yeah, I'm Peter Bayer. I live at 10 Prospect. Currently renting my house to my neighbors who recently sold their house and moved into my house. I maintain a space in the house for myself and rent it to a family. Because I understand that I'm in an R2 district and it's got to be family occupied. Well, that neighborhood has changed a great deal since the house across the street went from being a chiropractor's office and a residence to a boarding house, essentially. And, you know, we can argue all day about, you know, whether it's a boarding house or not a boarding house. I'm sure there's lots of proof in terms of leases and rental agreements that the individuals that are living in that place are not related or whatever, but I mean, that's not for me to decide. I have an interest in maintaining that neighborhood as a residential neighborhood. And what's happening is that there's an encroachment of transient housing into the neighborhood. I have a 5-year-old daughter. And I bought a house in an R2 district 25 years ago, or almost 25 years ago, with the understanding that it was residential to family. So there is a question of value that's placed on, you know, that designation. So as the neighborhood encroaches on that, it changes what the value of my property is. And yeah, I mean, this is a kind of a NIMBY thing, but it's also factual. I mean, there's, you know, if I go to sell that house, things change. Because now there's a boarding house across the street. And it's not I mean, I've rented to students. I was a New Paltz student myself. I've had 2 student rentals in my house. I mean, I would rent 2 rooms out in my house to students. And I know what the difficulty is in trying to manage a rental. And as an owner occupied rental, I know what that difficulty is. So to have an expansion of a rental by the room place across the street. And I see I sit on my front porch and that front porch is diagonally across the street from me. So I see what goes on. And when people are out there till all hours, drinking and playing music and playing games in the street, it's very obvious to me that that's, you know, kind of what's going on there. You don't have to be a detective in order to figure that out. So it seems to me that Sam and Rick bought a piece of property with the understanding that enforcement was very lax on student houses that, you know, were rented by the room. And they made a calculated risk. They bought that property with the understanding that, well, okay, if we need to rent this by the room, and I know why they're doing it, they want to stabilize their income. They want to maximize their income and stabilize their income. And they rent by the room because if you rent to a family and that family moves out and you don't rent that house for a couple of months, you're losing X amount of rent. And to them, that's a business. They're making a business decision that doesn't have anything to do with the well-being of the neighborhood or the neighbors. And we don't have anybody to really go to because they're not there during the day. So the time that they're there are not the time problems occur. Problems occur late at night. And all night. So my bedroom faces the street, my doors are open at night, and you could say, well, close your doors, but that's not why I ran that place, or why I own that place. And it's super noisy. So if you were living across the street from there, if they were living next to there, it would be a different situation, but they're not there, it's not owner occupied. And that's the difference, I mean, that's what we're seeing, like people who are not there don't really have the skin in the game that those of us who are there have. So, I mean, this is kind of an issue, and they know what the enforcement is. And it seems to me like their approach, and I like those guys a lot. They have a really good business. I've been their customer. You know, I talk to them on a regular basis, but you know, they're pretty straight up about what they're about. And that is, they gotta make money. And their motive is profit, not, you know, the good of the neighborhood. And so what we're seeing is the results of that. You know, they can rent to a bunch of transient people who will maximize their profit, but at our expense, ultimately. So when you approve a use like that in an R2 district, what you do is you push those effects of a bunch of transient people living together closer and closer to people who have their families there. And, you know, there were a bunch of young kids there, you know, over the course of the years, and that has a very big effect on, you know, the well-being of and the security of the people who live there and their children. So it's something to consider, you know, like if you're given a variance to somebody who's doing something in an R2 district, and it's not really compliant with the definition of what R2 is, you know, that's the on the ground effect. And they're really not there to manage it. That's not their primary concern. So once you allow them to expand it, they've already got, you know, a bunch of people living in there. When you expand that, the problems, as I see it, are only going to get worse. But I don't know what your ability is to deal with that, but it's something to keep in mind when you do that, you know?
Unfortunately, that's not the board that does that.
Yeah.
Not the board that does that. That's the planning board.
Right.
All that stuff you talked about was all the planning board. I'm not supposed to comment, I'm sorry.
Well,
Yeah, anyway,
that's all right. Sorry about that.
no worries. I understand the frustration and I
Yeah.
understand. I'll sum this up better.
Yeah, all right.
That's the end of the list. I don't know if there's anyone else who wants to speak. There's nothing online.
Okay, does anyone want to add anything?
You want to see if there's anyone else who didn't.
Does anyone else want to talk? Before we have, okay, all right, we can discuss what we heard. Does anyone have anything?
Well, do we
to mention?
close the public hearing?
We're not closing the public hearing today. This feels very rushed. And if people have more information to give next week, I'd be more than willing to listen to them again. Because, well, we can discuss this.
You should do a motion to hold it over to the next meeting.
Yeah, well, let's discuss it.
If you
This is
decide-
not, okay,
But
so
our conversation should.
this, yes, yeah, well, let's discuss this first. I don't think we should close this public hearing because this feels rushed. Do you agree? So if I put a motion for it to extend the public hearing to next week, I think that would be, next month, that would be appropriate.
Absolutely.
Okay, so I'd like to make a motion to extend the public hearing to next month, October 8th.
Motion.
Second. Vote aye. Okay, so we're gonna have, if you guys need to talk more or want to discuss this more, that's totally acceptable to me. If we have more information, there's a lot of moving pieces to this. This is the first time we've ever done something like this, so it's a lot of moving things. Okay, would anyone like to discuss any of the information that we got?
Mr. Chairman, could we the village present, because we haven't been heard
Yeah, we're gonna,
yet. Okay.
yes,
Understood.
we're gonna want to do that, yes.
I mean, all of that, like you said, most of the time we're crossing on things that really aren't what
Yeah, we're not the planning board.
we're not the planning board, but that being said. Things are brought to us specifically when. Things don't fit into the rules. That, like, we were just asked, hey, I want my house set back 3 foot farther, that's against the law. And we're here to help our community fit into those situations. So we are the one board that's not supposed to follow things just by the law. We're supposed to put reason, we're supposed to put our,
Can I throw a concept in there? The fellow who asked, took across a lot of that porch, he's asking for a variance, that means a variance from the code. So that's an example where we're supposed to sort of set aside the strictness of the law and come up with a different perspective. What Mr. Duncan is asking for is something different. It's not a variance. It is an appeal, which means that we must interpret the law and determine whether essentially the building inspector was correct in what he says. So we are constrained to the law on an appeal. There's just an argument about what the law is.
right, and that's what I'm saying, is it's brought to us because it's not a clear fine line.
Arguably,
If-
depending on the side you're on.
Well, regardless, it wouldn't be here if everyone agreed where the law is, so that's why we're
And
here.
we will discuss some of those complexities.
Yeah, so, but that is my only point is that the whole reason that we're involved with anything is because not everything's black and white, and that we're the.
That's
we're the
exactly what an
brand.
appeal is. The appeal is to determine, try and make it as black and white as we can out of what.
Right, and so that is our purpose, and that is what we're going to try to do, is what's best for.
Well, we're gonna try to do what the law requires.
Right.
On appeal.
Using your example of the prior applicant, that was a request for a variance. Was a variance required for this particular project? Was a variance necessary to convert a single family to a 2-family residential?
No, well, the building inspector said no. If we were to decide, we were to agree with the appellant that that was illegal, then one of the options could be for the owner to come in and ask for a use variance, for example. So a variance is one of the ways around a very strict interpretation of the law. At this point, there was not, what I would characterize as not the strictest interpretation that some of the citizens would want. But we're gonna talk, when I got into some of my legal analysis, we're gonna talk about the difference between a variance and an appeal. But I just wanted to correct, because in a variance, in an appeal, we're being asked to figure out what the law actually is, without trying to figure out what sort of, exceptions we can make in the law because a person has a legitimate concern. This is whether or not the building department made the correct interpretation of the law. And if we decide that they did not, if the law is stricter than he says, then the landowner can apply for a variance. It's so we know we get around it. But then they have to come up with the requirements for variance, which involve a lot of considerations of neighborhood and things like that, and conditions and that sort of thing.
Do you guys have any other concerns with what we, information? Okay, all right.
Village,
Yeah, so I'm gonna ask the building inspector, Alex, to join me. So first, apologies for the lengthy document at the late hour yesterday, but as you see on the cover sheet, there's 13 different documents that we're replying to, and now number 14. And 5 of them were received a week ago. So Alex and I have been working all week to get this reply done. We wanted to give it to you in one document, not give it to you in 14 documents. So ultimately, what I can tell from the application is that what is being appealed is the issuance of the building permit to construct an addition to the existing structure that would then create a 2-family house. There's a lot of other information that's brought into the argument that's been proposed from the applicant, but So I'd like to just first start with, the building inspector has two roles. One role is, he or she is the administrator of New York State codes, specifically the New York State Uniform Fire Prevention and Building Code. That is a code written by New York State. The current version is 2020, correct? About every 3 to 4 years, it's updated. That is empowered in the village, it's codified under section 86, building construction. What that 86 does, it says the village of New Paltz is going to follow the building code. We have no choice whether we follow it or not. We don't have to have a building inspector. If we don't have one, the county is required to take over the program for us. But because the village trustees have adopted section 86, we have a building inspector. The second thing the building inspector does is administers the zoning code and the other codes involving land use in the municipality. They're two very different things. The land use code, the zoning code, the subdivision code can be, as long as they meet some minimum statutes of the state, the village can write the codes as they choose with the standards they choose. It's called home rule. So they have the opportunity to write their own code. This board is empowered under state law to hear. One of the things you do is just what you're doing right now, hearing an appeal. But what you're hearing is an appeal to the zoning code. This board does not have any authority that I am aware of. Council could probably confirm or not to decide whether building code is being administered or not. And there's a document that we include in our packet from the Department of State, which explains exactly what the appeal process is if someone thinks the building inspector in enforcing the New York State code is not working properly. And that's an appeal to a state agency. Or you can file a complaint that an agent, because in order to be the building inspector, you go through New York State training, you're certified by New York State. They give Mr. Salamitri his license to be a building inspector. And then the village is able to hire him because he has that license. So it's a very fine line. It's two positions. But our position is that any of the aspects that have been mentioned in the appeal about the incorrect enforcement of building code, meaning the New York State Uniform Fire Prevention Building Code, can't be heard by the board. So we start with that. Certainly a number of the complaints are about zoning code. I agree. Those can be heard by this board. The second part is there is a section of state law that talks about the time frame that a determination can be appealed. That time frame, and we cite the section of code, is 60 days from the date of the determination. This project started not with the building permit being issued, but way back in 23. As a matter of fact, on March 31st, 2023, the former code officer made a determination sending this project to the planning board for site plan, where he made the determination this was a single family residential use being expanded to a 2-family residential use and met the criteria. And our position is that when he made that determination and forwarded it in his written letter, and that's in the document here, that's the day the 60-day clock should have started ticking. Because that's the determination that is being argued by many people, in that it was mischaracterized, that it should have been a rooming house. So that date would have come and gone, the 60 days. And I put the exact date in here, but at some point in May of 23. There is case law out there that says perhaps a neighbor doesn't know that that determination has been made on that day, fair enough. But there's also case law that says when somebody becomes aware of it, the 60-day clock can start at that point. There's two records in here of letters from Mr. Dungan to the planning board, one in March of this year, February, and one in March. So, and they're about that very topic, that he believes it's not a two-family house. So clearly, if he was in writing that letter, he was aware of that determination. So the 60 days, if you didn't start it back at March 31st, 23, at the very least, it could have started then. By the time the appeal was filed, it's too late. Regarding the contention of the rooming house, I think you said it very well. This board has to look to the definition in the zoning code, which clearly does say owner occupied. So that would dismiss the claim that this should have been ruled a rooming house by the building inspector or code enforcement officer because it doesn't meet the definition. And then finally, about the family, we include the entire document that the state puts out, which is 19 pages. And the site that has been cited, well, the city of White Plains versus Ferrioli, is a case from 1974. If you continue reading the document, there is case after case after case after case, which takes that original opinion and makes changes to that original opinion based on, obviously, we're talking 50 years ago. So the case law does support that the definition of family does not have to be related. So the building inspector was using the definition of family in our opinion, correctly ruling that this is a two-family house. So I don't want to take up a lot of your time. Our information I believe is pretty thorough. I'd be happy to, I know many of you probably haven't seen it yet because you got it yesterday. We'd be happy to answer any questions at any time. Do you want to add anything? So it's simply, I understand that the neighbors don't believe that this is a two-family house. I understand that they think the zoning district doesn't allow it, but it's our contention that the way the law is written, not only does it allow it, it was the only choice of what it could be as to how the code is written. If the code is written vague, then they should petition the town board, village board, to correct that code to be more what the community wants. But the building inspector they can't make up the code, just like you guys can't make up the code. They can only follow what the code is. So.
Okay, any questions, guys? I just have one question.
Sure.
You said with Ferrioli, the definition of family has changed. Has the definition of a temporary living arrangement changed in those 50 years? Because they cited that, they specified college students and sharing a house. Has that changed in any way since that?
I don't know, to answer your specific question, I don't know the answer, but if you read the rest of that document, they talk about unrelated people living as a family.
Right, no, I read that. The only thing I didn't see was if there was any change in regards to that.
I can research that, and I don't know the answer to that, but I can certainly research that.
That's probably a question for us.
Yeah, thank you. That's a very good question.
Anything else? All right, good. Okay.
Thank you.
Barry, come on down. Yeah.
So, I just want to say, first of all, I have 8.5 years experience in village government, including 2.5 years on the zoning board of appeals, finishing somebody else's unexpired term. So make no mistake that I have a lot of respect and understanding for what the board does.
It's weird how you started out insulting us.
Good.
It's weird how you started out insulting us and saying you were shills for people. It's weird how you started off. It was not a good move.
Anyway,
I've been doing this for over 10 years and not once has the mayor or the village board ever approached me and tried to influence anything I've done. I've been completely independent of them. I started out as a regular person, now I'm the chair.
Right.
And what you said infuriated me at a very high level because it's so wrong on what's happening and how this board is. I've been doing this for a long time. I've had one person, I think my whole time here, try to influence something, and they were just a neighbor. Okay, it's never happened. The mayor's never talked to me. So the board has never talked to me. There is complete autonomy here. I think you guys are new, but would you agree?
I mean, yeah, I'm a few years in, and I've never been addressed in any way.
Yeah, if anything, I don't know who the people are. So that was completely incorrect, and I would love to talk about it, but I couldn't at that moment.
the problem is that when you make a statement, that you're gonna follow the trustees' policy, that's not law. They are welcome to their opinion. They can decide on it and they can write an opinion paper, but that is not law. And the board is responsible for the law. And it's really critical to differentiate between the two. So to say we have to follow the trustees' policy, that is absolutely incorrect. The problem is that being able to tell people that they're exempt from the law is a power that could easily be misused, whether by intent or by mistake. And so there is a huge body of law regarding that power and controlling it. The guardrails that surround the ZBA are extraordinary because of the possibility of making a mistake. And so that was just the point, that to say this is the trustees' policy and we have to follow that, absolutely not. It is only the law that you follow, and their opinion is not the law. I don't know if you have anything you want to say to that, or no. Okay. Anybody else have from the presentation last time, were there any questions or something you need clarifying? No. All right. There was a couple of points made before the village. First of all, keep in mind what the appeal is about. The appeal is based on section 212, 63C. That is the law which underlies the whole thing. And one of the key things, so talk about a determination of a previous building inspector or other things like that, that's irrelevant to this appeal. We, several neighbors had filed a complaint with the building department in July regarding number 7. And the opinion of the building inspector or the building department in response to that complaint, that is the only thing that is relevant. The opinion expressed by a previous building inspector in some other year is irrelevant to this appeal. Also, on the issue of not being able to consider the matter of the state law, if you look at the law that the appeal is based on, which is 212-63C. That says that the permit, that is what regulates in zoning, the issuance of a building permit. So the building permit is also regulated in section 86, but that is, as a matter of zoning, it is 212-63C, period. So to say that you cannot consider matters related to the building permit, the issuance and so on, you absolutely can, because that is in the zoning. There is a number of things in the zoning that mirror what is in other sections of the code. But if it's in the zoning, then it is within your purview, even if it overlaps something else. And that is the case here because 212-63C talks about what are the preconditions for the building inspector to issue a building permit. And those must be met. And because they are written into the zoning, they're absolutely within your purview to consider. So for somebody to say that's another part of the code, well, you can't talk about it, that's not true. It's mentioned in the zoning, it's written into the zoning, and it is in your power. The other thing is that when you read 212-63, it specifically says that one of the conditions, preconditions for issue of building permit is compliance with the state law. For the purpose of hearing the appeal, you are code enforcement officers. And the law says that you have all the power of the officer whose action is being appealed. So because the zoning specifically mentions compliance with state law as a precondition for issuing a building department, the building permit, and because you are effectively code enforcement officers, it is absolutely within your purview to consider whether or not there were violations of the state code. Because if there were, the building permit could not be issued. And that is the decision that has to be made. Was the building permit properly or improperly issued? And part of that is the violations of state code that are mentioned in section 212-63C. So the state code reference is part of the zoning law, and it is within your purview.
Okay, all right, so I visited the site. Okay,
Which site?
I went to the 7 Prospect Street. I went inside.
Oh, yeah.
Okay, so when I went inside, the staircase is not in bedroom number 3. The staircase is in the kitchen.
Yes.
Okay, so the staircase, the privacy where that should be in there to join the basement area, the first thing we said in terms of part 122640441.
Right, yeah.
Yeah, that's, I inspected it. So the access to the basement is through the kitchen.
But that's not relevant. The law says issuing the permit was conditional on the permit that they had, on the plans they had in front of them. So if the permit was issued in reliance on unlawful plans, then the permit was invalid, regardless what may or may not have happened in the building since then.
No, it was always like that. There
It was
was
always like that,
there
but
was
the
a
point is, the plans were to change it, and the permit was issued in reliance on those plans.
wait, what? So right here, in your document, it says that the bedroom may not concede the only means of access to a habitable space or common areas within residence according to the plans. Bedroom 3 is the only means to access the basement laundry area in the
Right,
existing
yes.
home. Okay, that is not true. So,
It is true, because you
No,
just
I-
said, you just said the words, according to the plans. And that is key. The building inspector issued that permit
Mhm.
in reliance on plans that were unlawful. And when the building inspector takes an action like that, that makes the permit unlawful. The fact that the
So you think if
condition,
there's one mistake in the plans, then that means the building inspector is at fault and the plans are no longer valid. So like, so if a measurement is off, if the bathroom is flipped, so you're saying like there's a toilet in the wrong spot, that would be grounds to. You're claiming, and I'm gonna check with our lawyer
Sure.
because I can't imagine this is true. But so what you're claiming is that if there's one mistake in the plans, so like your other thing that you were talking about was in some of the plans they had a chimney and some they didn't. And so what you're arguing is that there's one mistake in the plans and the plans are no longer valid.
it's more than that, because like you just mentioned several,
I mentioned two.
you mentioned two, but if you look at, if it is. Now let me train of thought. If it is a minor thing, but for example, the window is too small in bedroom number 2,
Okay,
but that's easy to fix. You put in a bigger window,
yeah,
which is completely different than having no window. So there are degrees of seriousness. But when you have something where there are, in this case, there were 3 errors in law in the plan regarding the state law. And I just lost again.
here, let me ask our lawyer for clarification.
I think that,
So, if in a set of plans that are submitted to the building inspector, if there is one mistake in it, would that mean that the building that means they're illogical plans, and then that doesn't seem to make any sense to me.
Honestly?
Because there's mistakes in plans all the time.
That's an interesting claim that I would need to look into. There are certain reasons why it would not make sense, because, I mean, one of the things that we deal with in the law is, all right, assuming that what the claim is technically true, what's the remedy? In this case, the remedy would be to go back and have I mean, if there was to be a remedy, it would be to go back and have the applicant correct the plan. And then you would have, then you'd be able to reissue the building permit. Most people wouldn't bother. So the short answer is, and I'm not sure how much we want to discuss all of this, but on the substantive claims here, substantive means actually, let me back up. This is more than you asked for. I'll try to be as quick as possible. The village presented the idea that there are issues under both the zoning code and the building code. And for both of those sets of issues, there are what are called jurisdictional claims.
Okay, wait, we're gonna get to this in a minute. I'm gonna cut you off. I'm sorry. I just needed clarification on that one thing. I apologize. Because we're gonna go there.
That's on
Let's go there.
the research part.
Okay, all right, all right, so we're gonna have it, I don't know, let's discuss this. So what do you guys, how do you guys feel about this? Because I've looked at plans all the time and there's mistakes all the time and we just cross them off and go. Like,
So I don't wanna speak on your behalf, but I believe that in this case, and I would wanna look for precedent in this, is that you're stating that the error made it to where the inspector's decision may have been different if that error wasn't in it, because I could see that being an argument, but if that's.
No, but if the building inspector knows the physical layout.
Right.
And the building inspector issues a building permit based on that physical layout that he is aware of. The claim comes down to the idea that the paperwork wasn't right, and therefore technically they didn't follow a particular provision that required paperwork to be submitted. It's a paperwork issue. But presuming for the sake of argument that the building inspector was aware of where the staircase was, had judged whether or not it was legal, and proceeded to issue a building permit based on that, the claim is that the preceding paperwork is not correct. That's what is, as I interpret it, assuming I heard Mr. Duncan correctly, which can be right or wrong, that is the claim. And that's why, again, a lawyer would say, basically, so what? Well, what's the remedy is just to go back and do it again?
And then we'd just be.
Isn't that what it says in the resolution from the planning board? And again, the site, I guess my first question is the site plan that, that Alex, issued building permit for, is that the same site plan that, has anything changed in that since the, building permit was issued? Is that the final document? And if there have been changes, according to the resolution passed by the planning board, then it would be, they'd have to require some resubmission and reapproval by the planning board, if there's any changes to that.
Assuming this was even covered in the site plan, which I'm not sure if it was or not, but.
Yeah, the building plans.
I don't know, as I sit here, I don't know all the specific underlying facts, but I think that the claim is basically the paperwork was wrong, even though it's quite possible that the building permit was issued consistent with both the actual physical state of the property and because of that, the actual law. Now, I'm just speculating, again, I haven't taken a deep dive into this, but I think that that's what's on the table here, is that it's a paperwork claim.
Okay. But yeah,
Cause I mean, you've worked off of plans before and. But there's always a mistake in there.
well,
I mean, not always, but there's a lot of.
There's an enforcement based level of egregious mistakes that invalidates the plans, and so we're trying to decide if the mistakes in the plans are egregious to our understanding to the level that would make the paperwork or the site plans
invalid.
inefficient or
And then any
insufficient.
decision made based off of them would then be.
So the decision then would be to go back and do it again.
But if the building inspector is the person who's making this judgment call.
Right.
And they looked at the plans. And then they walked through the property. And they saw that, oh, the staircase is accessible, the electrical panel is accessible, the laundry panel is accessible. Then
Consistent with the code.
consistent with code, then there would be no reason to.
Well, if the paperwork,
Because they weren't doing any work on that part of the property.
That's a good way to describe the conflict. Did the building inspector have to throw the thing out because the allegation is that the original paperwork was wrong? Because when he was able to see what the real thing was, that's essentially the claim boiled down.
Are we able to speak to the inspector?
Yeah,
Yeah, at some, yes,
Yeah, we
one of the things that will happen here, if we wish, is to ask the village representatives.
Well, because we're
Okay,
speculating
but-
over
And
whether things were seen or what was taken into consideration and.
he's here now.
right there.
Yeah, it's a public, if you want, you can ask him about it.
Cause I mean, if that's the question right now is if. Well, would it have, like you're saying, like, would it have mattered if you noted, then is that the case?
Okay.
I think it's best for us to call Alex down and talk about.
Well, we probably want to get Terry through all
Yeah.
the stuff and then we'll go left house, and that'd probably be the most,
Yeah,
that'd be the fastest way to do it. Okay.
just in
Okay,
that.
so is there any other things you wanted to bring to our attention?
Well, I guess part of it is that the building inspector, part of the job, both in our code and as written out by the New York Department of State in their publication site plan review. It is the responsibility of the building inspector to review the plans and to make sure anything which is wrong in the plans is corrected. And that is what should have happened before the issuance of the permit. When the planning board gave their approval, there were members who had concerns about the efficacy of some of the things that were there. And they gave their approval on the understanding that the building inspector would straighten it out before writing a permit. And that did not happen. And that's the thing that concerns me. And you can say that because executing a bedroom according to those plans would have been very serious. But if you want to ignore those for now, you still have the issue of the lot coverage, where the plans that are shown have excess lot coverage of about 200 square feet. And that should have been corrected before the building permit was issued. Because exceeding the lot coverage is actually quite serious. The too small window, that's easy to fix. The problem with the dining room, that's easy to fix. But the lot coverage is more serious. And to give a person permission, to go and start the construction when you have the lot coverage issue unresolved, that's more serious. Figuring the lot coverage is not hard. It's all just basically plain geometry. The area of a rectangle is length times width. So it's easy to figure out how big the buildings are, how much area a sidewalk takes, or how much area the driveway takes. It's simple geometry.
All right. Oh. Is there anything else you need to give us or tell us about?
Yeah. So this is the communication of our attorney. And there's copies for the board. That's what we need.
Yeah, okay, so is there anything else? Is there anything else you want, is there anything else you'd like to tell us?
Good for tonight.
Okay, good, thank you. All right, come on down.
To the board, we've got two brand new communications and we'll be responding to both of them.
Okay,
So
all right.
I don't want Alice to have to try to answer off the top of the same thing.
All right. So. All right, so. The first thing, Alex, usually you would have a lawyer representing you. Or being with you, so if at any point you feel uncomfortable or, he asks you questions about where you live or something like that, you feel, just let us know and we can table this and do it at the next meeting. When you have counsel, I don't want you to feel stressed in any way. Okay, because every time that we've had a building inspector talking to us, there's been a lawyer next to him holding his hand, so. I know you're comfortable, but if you would at any point feel uncomfortable, we will not hold that against you or feel anything weird. Okay, I think everyone would agree with that? Yeah, okay. You can read him the Miranda. Sorry. What?
I said that it's no longer in his.
Oh, he probably has a number, I'm guessing. So that would be the first thing I wanted to tell you. There was something else I wanted to say before you start talking. No, that's it. Okay, you had a question, so why don't you ask it? And
Well, it's hard to even frame. Yeah, so I guess.
I think we can agree that the plans were poorly drawn.
Yes, yeah, no, poorly meaning making understanding.
Yes.
If you want, I can go into a few of the points that we're just talking about. The issues regarding the third bedroom and the access to the basement and whatnot. On the plan that is shown on that northwest corner of the kitchen area, and on the plans it's indicated as south, but it's indicated kind of on the wall, so it could be considered either the bedroom or the kitchen area and the swing of the door
is kind of the diagram shown on the plans, which is a little bit confusing. Furthermore on that, it leads to an uninhabitable space, the basement. It's an unfinished basement. It's not used. The plans are gonna be to remove the laundry and dryer from down there. So even if it was in the bedroom, it wouldn't matter. It's not a common space for people to be. It's not a living room, a bathroom, a game room or whatnot. On that,
I'm sorry, Alex, which didn't matter, the bedroom's not finished, or the?
if the entrance was in the bedroom itself,
The bedroom's not. used
but the
as a-
bedroom is not, the entrance to the basement isn't in the bedroom, it's in the kitchen.
But
but
even if before you're saying that because that's not a shared usable space, it's
Mhm.
irrelevant to the code.
Yeah, correct.
Meaning the basement.
Yes, it would be similar to if you had access to your attic in a bedroom, right? You have a cutout. A lot of houses have access to different portions of the attic.
So the bottom line from your perspective is that nobody's really going into the basement, therefore there's no need to access the basement through that particular bedroom.
Correct. But
Even
that,
even if you did consider access to.
yes, yes.
If it was considered like laundry for the whole house, then that would be.
That would be separate. That would be different because that would be a common use. If everybody had access to the washer and dryer, that would be a shared utility. But it's in an unfinished basement, so it needs to be removed because the access down there is not good.
So when that section of the plans were unclear, or maybe even you determined were not accurate of what is currently there, because the outcome of it didn't, like, am I?
Yeah, so
That's why it wasn't.
correct. In my building review of it, of the construction document, not the site plan, but the actual building code itself. I go to whatever is either building or residential, and I just go start from the beginning, and I go down and see whatever that applicable and go through, and that was one of the things that popped up. And in my opinion, it had no effect on that. On that. Yeah, so that's pretty much, my whole case for the third bedroom claim. Now, the claim for, and let me just go back for a second. We have to keep in mind that there is no CO issue for this building, right? So the construction of the new part is not, it's not done yet. There's no, people can't be living there. There's nothing established. It's still under construction. So prior to the issuance of a CO, which would be the complete outcome, everything's done, everything's code compliant per my understanding, or so forth, I would request a copy of as-built. So that is a set of plans that the architect would go back and review the whole building and what was done, and any changes or things that pop up will be illustrated on this set of as-built and can be reviewed again by the code before issuing the CO, but also so we have an understanding of what's actually there. Because a lot of times when you open up walls or ceilings and stuff, things pop up where there might be constraints that do not allow you to practice a certain type of construction. So things do change throughout the process, and it's fairly.
So at the time of as-built CO compliance, that would be something that at the time, at the initial time, it didn't affect the outcome of any of your codes as you saw it.
Mhm.
So that would just be something that would be fixed.
Correct, and that would also go along with the kitchen complaint, saying the kitchen or dining area isn't big enough for the structure, for the maximum amount of people there. Terry was correct in that it is a minimum requirement of 80 square feet. If you look on the plans, there is a call out for a den. It's, I believe, south of the kitchen. And that just needs to be changed on the plans to kitchen or to dining room. I'm sorry. And that room is 8 by 15, so it's 120 square feet, and that's not including the bump out of the windows, which adds probably about another 10 square feet. So it is already over the 40 square feet of the minimum requirement for a dining room. And then if we go over to the site plan, Mr. Terry submitted a photocopy of the site plan. I'm sure it's in the Google Drive. That's where I got it from. with the calculations for the impervious surface, the lot coverage, which is again in the R2 zoning district, which will require a maximum of 30% lot coverage. And throughout reviewing his calculations, they did seem to be very accurate into actual dimensions. But there are two things that were missed on the site plan callouts. There was an existing bluestone patio on the southwest side of the building, on the back portion of the new addition that is to be removed prior to the issuance of the CO. And on the 4 parking spaces on the north side, all the way at the end of the driveway, those parking spaces consist of about 648 square feet of impervious surface, or pervious surface. So that doesn't add into the lot coverage calculation. So just off that, the lot coverage, the issue with the lot coverage just by the parking spaces itself will bring him underneath by little over 200 square feet.
Alex, could either you or Mike give us a detailed workup of that calculation? Copy to Terry. So we can take it, because I don't believe that was in your submitted list tonight.
No, this is
not, because it just came.
So that's, okay,
yeah.
we need to see that.
Yeah, so that seems to be once again a situation where a part of the construction is going to change and would be the final resolution would be approved if it didn't fit into that, but while in construction right now, there's something that's been added and something that's going to be torn out. So at this current time, it's over.
At a certain time, the building permit has been suspended. He has been issued a notice of violation order to remedy for non-compliance of the site plan. There was the addition that needed to be removed and it hasn't been. That was noted later on in the building process than it probably should have been, but prior to the framing inspection being completed. And with that, now he's being, with my notice of violation order to remedy, part of that would either be to conform to the site plan, so remove the portion of the building that's still there and then move the entire building into a conforming spot, or to go back in front of planning board and get a site plan amendment for what is there right now.
So Alex, is that the only change in the site plan from the one you used to issue the building permit?
Yeah, so the only change from what is the approved plans and what is existing there now is a portion of the, about 11.5 foot of the building was noted in the site plan to be removed, but was not removed, and the addition was put onto the north side of it, not in the right location, not just because of the building still existing there, but it was shifted a little bit south, I believe. So either, again, going back, he's gonna have to remedy those 31 of 2 ways.
Yes, so you've taken action against that error.
Yes, yeah, no, that has been.
So this isn't a.
And the applicant has chosen to pursue a new site plan with the planning board. They're currently in front, they have an application, they're currently in front of the planning board. It hasn't reached public hearing stage yet, but they are in front of the planning board to amend the site plan that was approved in May. And the planning board will decide if they allow it or not allow it. And if they don't, then either the owner has to build to the approved site plan, or he has to remove what he has done already.
Which is here nor there to your decision. Once it comes back to you, then it'll be. Because you made a decision, he didn't follow it, now he's going about doing it.
How long is that going to take for them to eat, for the? In your question, optimization, using that term insanely loosely, what is the approximate timeline for them to get approval for fixing that kind of plans?
It's really at their pace. They need to go in front of the planning board. I know they have already supplied plans to the planning board for review. I know they weren't there at the previous meeting because they were still working on the set of plans.
They'll be on the agenda again October 1st. They chose to come off this past meeting's agenda because they were exploring other ideas.
And they only really have two options, either the planning board gives them approval for it or denies it, and they have to conform with the original site plan.
Now, if the planning board approves it, that would entail a new building permit, right?
Now, until a new review of the building permit, they saw the building permit for the construction, but there's changes to it.
Or wouldn't that building permit have to be altered because they're gonna be
Yeah,
constructed?
yeah, the new set of plans would be issued.
Well, let me farther, I think, north or over there.
Yeah, no, absolutely.
You need a new building permit.
Mhm.
All right. Thank you. Thank you.
Don't go too far, we may have questions.
Yeah.
All right, so,
Mr. Chairman, can I respond to one of the public hearing comments? So there was or maybe Alice could address this too, the question about the trees that were removed.
okay,
They are not, they were shown on the site plan to be removed and replaced with new landscaping. As part of the building permit, because the building permit is suspended, they've been stopped. The tree was taken down, but the plans have a replacement on it. But it is not within the setback that it had to go before the Shade Tree Commission. I don't know if you can build on that, but
No, he's absolutely right.
okay, that's fine.
So based upon the stop work order, they're not allowed to take down any.
you can't do anything. The only thing we allowed them to do was to put the windows in and the door in to make the structure weather and safety secured. So somebody didn't try to like move in and live in it.
There's no door on it.
It's out of order and as soon as
Oh,
it gets here, yeah.
Man, if only they knew how to attach a piece of plywood to it.
Yeah, yeah.
They had like a screw gun and a piece of plywood.
But-
And
So once the stop work order is issued, they were allowed to continue to put the windows in and to secure the space. But beyond that, no other work can take place.
All right, so we have 120 pages here to read through?
Yeah.
Okay, my brain's starting to hurt. Is everyone else's brain starting to hurt? So let's talk about some things here. So the first thing, this is going to happen at the speed of car going uphill in December. I think we can agree on that. So we have time is on our side. We do not have to make any immediate decision. Dave, you're on.
Okay.
Now I'm ready to listen to you.
There's a lot of stuff.
Okay.
As the chair said at the beginning, there's a lot of moving pieces to this. I want to make a couple of comments at first on some of these, sort of some of the initial things, and then I want to get into the specific moving pieces on this process. First of all, I want to try to find my notes. First of all, Harry made a comment about the board being prejudiced, and the chair, I think, interpreted that, or another comment as meaning that the board was hearing from the village board. I interpreted it as that was the same issue slightly differently, because it was something I think Terry had written and said last week, which the board needs to be aware of. And we can talk about it. And that's the issue of the fact that, as a theoretical matter, my partner, Emily Svensson, represents the planning board, and from time to time works with Alex on building department issues. And there is, when it comes down to legal conflicts, like basically between lawyers suing, with their clients suing each other, there's a variety of different rules that, you can't be adverse to your client, and your client counts as your partner's client, okay? And that's what Terry referred to at least once or twice, and it may have been when we talked about you guys being prejudiced. So I want to make a couple of points there and ultimately leave that decision up to you as to how you want to utilize me, if at all, because he has a point, but it's not, in my view, it's not as at the level of heightened concern as he's raising, so we'll put it in perspective. Again, that's what would happen if people were suing each other, and it's a matter of legal ethics. But Terry's concern is not the legal ethics. That would be your concern if we were suing the planning board and Emily and I were on opposite sides. All of a sudden, the red flags would go up and everybody would maybe want to get out of that situation one way or another. This is the concern of a person who has the right to have an impartial ZBA, and that's where he's coming from. And so that's the way you should judge whether my giving you advice is partial, because Emily is theoretically at times, she did represent the planning board, and she at times represents Alex as well. Now, here are some of the facts that should help me make the decision. The most important single fact is that you are the decision maker and not me. So this is different than if I was sitting up there, or if you were biased, where he also has a right not to have you be biased in one way or another. That's essentially what I'm saying, is that you're biased because of me, but you're not me, and the decision is yours. The second thing that's important here in terms of the fact is that, in fact, Emily did not work with Alex on this particular case. She did work with the planning board, but she did not work with Alex. And in fact, thirdly, I'll tell you that in some of the issues that have come up, I've talked to Emily about this, and we've disagreed on some things, including some that I will describe to you in more detail. We're not of the same mind. She's not in any way representing Alex or Mike or the village here. She would, if it came down to questioning the planning board, that would become an issue. So that is the entire issue that's before you on that, and you can make the decision whether to listen to me, not listen to me, find another lawyer, etc. My advice would be that because Emily was not working with Alex on this, it's probably not really a thing. As for the legal theory of it, I'll say one more thing. It is not unusual, especially in small towns, for one lawyer to represent the entire town, the whole thing. You're in a kind of a unique, it's not unique because everybody does it, but within the village governmental structure, you're in a kind of a unique situation because you're sitting in judgment of the village. That puts the village on two sides of this question, at least. It might even be a third side if the planning board and the building inspector were at odds, etc. So this is not in any way unusual. And in fact, the smaller the town, the more usual it is. And you don't even usually get two different lawyers. Sometimes it's just one lawyer representing a particular small town or small village. So this is not the first time this has ever happened. We usually do not require that you go out and find a new law firm. At one point in the past, we did ask the village attorney, Will, to stand in for the village in one of the appeals. So that's a matter that, you know, the village board is thinking about, and you should think about, well, within the context here. The question for you is whether you feel that your deliberation, your ability to be fair to all the parties here is in any way compromised because of my relationship with a lawyer who represents the planning board and sometimes, but not here, works with the building department. That's what that is all about. And you do need to think about that, because if he raised it, some people would let it go. Like I said, it's not as bad as you find in other places where one lawyer would just automatically jump from representing Alex to sitting with you and representing them. That's just out there on the table. I will also, in the same vein, Mike is wearing two hats as well, because he does your administrative work, and he's also obviously working with the village on their defense here. I've spoken to him about this, and I've said, we still need you to do the administrative work, but you're just doing balls and strikes for us. His work here, more to the point, is going to be with the village, as certainly can be. He's the village administrator for planning and zoning. So those two issues are before you now. You should make the decisions that you think you need to make in order to be fair about this. That's the bottom line. You have a responsibility to be fair. That's what the appellant has asked for, and he does have a right to that. I don't think, my personal opinion is, I don't think my work here is being compromised, and if anything, Emily's been working, she hasn't been working directly with me, but I've felt free to walk into her office and ask for details as to what the planning board did, or help interpreting some of these provisions we're going to discuss. She has not been representing the village on this. That's just a point that we need to just get out there.
Should we quickly do that? Well,
I'm sorry?
professional.
Should we talk about that right now?
Go for it.
I guess I have one opinion is in your case. Working with us right now, your main function is to record what we're doing and we all review that.
And taking documents and from the public. That's right.
If I were to read this month's like write-up minutes and it was not the way that I saw it, it would have nothing to do with whether you're two hats or not. I would call you out on it regardless. So
As you should.
there's a check system to that, in my opinion. And then it's as far as law counsel, no offense, but when we ask questions to you, I'm asking for your experience and interpretation of the law, not your opinion.
That's right.
And so for me personally, I see that.
Don't have troubles, legal counsel, the influence on either side, then answers are black and white, we're utilizing is to clarify legal interactions that we are not clear on, and I don't feel that, I'm not worried.
Well, we may get into some legal interpretations that are not 100% black and white, and that you will have, I will tell you, you will have some discretion on, and I will tell you some of those I think about it. You are free to ignore me. You're free not to tell me anything unless it's black and white, but I think you'll be undercutting yourselves if you don't. So it is out there legal, you know, as I said, Emily and I flat out disagreed on one of the issues that is before us, and I will represent her perspective and I'll represent mine, you know, I'll be as fair as possible, but it's just, it's just a basic process thing that you need to become comfortable with, or if not.
Yeah, I'm not worried about legal counsel influencing our decision-making process.
Yeah.
I'm the same.
I will tell you at every stage that the decisions are yours, including the ones that are legalistic, and we will get into some legalistic decisions, but I am not the decision maker. I will tell you that.
And you always have in the past.
The other thing I want to point out, again, that you guys know, part of your job here is going to be to design the procedure by which we get to a decision. There's a lot of moving pieces here in terms of submittals. Obviously, I would suggest that the fairest thing for everybody is to allow everybody time to respond to what's come in. Obviously, we got one 24 hours ago, we got one 24 minutes ago. And so the point is that the party should have a chance to. Now, you may want to decide that there's going to be a deadline for written submittals so we can actually get some business done next time. That's entirely up to you. I'm just suggesting it. You may just want to make the deadline at the next public hearing, because they can say it orally anyway. So in which case, it'll push it back another month. So what part of your job is going to be to design a process here by which everybody can be heard on every issue that's important to them, and at some point, even courts cut short the ability to respond the third or the fourth time. You know, you don't get so many, the number of bites is limited, but clearly here we did get very substantial submittals, and in some cases for the first time within the last 24 hours. And so it's going to be up to this board to figure out, to announce what everybody's time frame is, what the order is going to be for written, and then continuation of public hearing. So those are the moving pieces that the overall moving pieces I wanted to talk to you guys about in terms of just sort of process before we get into the particulars of the appeals, which I can also begin describing to you, at least as I'm breaking it down. So is everybody okay with that? Do you want me to continue, or do you want to digest, or what do you want to do? Want me to go into the actual substance? All right. I'm looking at everything that's being said on the appeals in 4 boxes, which is nicely arranged 2 by 2, which I'll explain to you, and it's going to have certain implications. As the village described, and there are 2 sets of laws here that you're being asked to consider. One is the village zoning code and compliance with the village zoning code, and the other is compliance with the building code, which is actually a function of village law as incorporated from state law. For both of those sets of analyses that you're being asked to do, there are also what's called jurisdictional arguments or jurisdictional objections, essentially allegations from the appellant, actually allegations from the village, that you don't have jurisdiction to hear them, different arguments in different cases. So you've got an argument that you're not entitled to hear an appeal based on the building code because you only can hear the local code. You can only hear an appeal on the local code. And that's jurisdictional. And I can discuss that in a little bit of detail, or we can allow further briefing on it, depending on how you guys want to deal with it. There's also a jurisdictional argument that you're not allowed to hear the appeal from the zoning code issues. And that is based on statute of limitations. The argument that it should have been done within 60 days of the original CEO determination that was actually done by Corey. And we can talk about those as well. So you have procedural, jurisdictional arguments that you can't even hear the appeal. And then you have the actual substance of the appeal, which is complicated enough. And I will tell you that I am, as I sit here tonight, more well versed in being able to talk to you about those jurisdictional issues if you decide to handle them up front and however you want to proceed on hearing them, deciding them, briefing them, etc. The substantive stuff, the stuff that's like is the staircase in the right place, those sorts of things. I'm just going to need a little bit more time, or you may just decide to cut me loose entirely, because that, you will also decide how much you want to rely on me. You may decide to rely on me more for the jurisdictional stuff or not. These are all your decisions. But I'm just sort of telling you how I'm breaking it down and to throw it back to you to figure out how you want to proceed and how you want to use me in that.
Okay, I, a question, I'm gonna throw this out there. So my issue with the timelines is,
You're talking the argument, you can't hear the zoning.
Yeah,
because we're too late.
yeah, I have a huge issue with that. And here's my theory on this one. Until you actually see the thing, right? How are you supposed to know that it was awful? You know what I mean? Like, and like the whole idea that, oh, you're 3 days later, I get the reason why they have. I totally understand. It's funny, I was listening to a podcast on this today, on like, absolute timelines, like that this ends. As a board, can we say it's okay that it's late?
That's a good question.
Because I know we've done that before in the past, that we've been like, okay, this is 3 days over, but we'll just let it slide. Like, we've done that multiple times where we've said, this is over, this time is over, but.
Courts generally do not have, and New York State Supreme Court, I've never seen them just exercise discretion in not applying the statute of limitations. Now, having said that, the limitations period here is not a court statute of limitations, it's actually a time frame that's in the village code. So your real question is, does the ZBA have the authority to kind of throw out the requirement of the village code, which is really for the village's convenience? In general, I've never seen it. I don't know what the rules are. I don't know what your standards would be to do that. So it's something that is foreign to me. But again, I'm going to tell you that it's your call. My own experience and my own advice would be that I think that ignoring statute of limitations is not typically done. And it was pointed out, however, there is an exception to the statute of limitations for coming to the ZBA. There is some court cases that do tie giving some leniency where there's an argument that the appellant may not have had notice of the decision. Unlike if your decision here was going to be, if you were being sued, so it would go to the Supreme Court, your decision here is publicized. It becomes it's in the minutes. It's going to be put on the village's website in one form or another. A building permit, which can engender an appeal to you, is not necessarily publicized. Alex doesn't have a public hearing on a building permit. When he issues one, he doesn't publish it. You do both. So everybody has an expectation. Plus your decisions get filed in the office of the village clerk. That makes it inherently a public document from the minute you do it. That's why the court doesn't have to listen to an argument that we didn't hear about it, we didn't know about it. It's automatically, this board's decisions are automatically public. The thing to understand is that Alex's decisions aren't, but the statute of limitations applies anyway. Unless, and again, there's only a few cases that do give some leniency if the appellant argues, we just didn't know about it. It was the village, the building inspector decided to put it in the building inspector's files. There was no hearing, we didn't know about it. I've seen a couple of those, but the appellant hasn't proven that. So if you want to go down that road, I can look more into it and we can, but it's not the sort of thing that's typically done.
On that note, my only kind of concern and hesitation in the same direction that you might be having it is like how exactly is that set up and worded? Because if it's 60 days, right?
Well, we could look it up, it's gonna be right in the village code.
But we have things that currently aren't the way that they're supposed to be. And we're saying, oh, well, that would be suited out on the plans in the finalization. Like, how are we to expect?
Yeah.
You know what I'm getting at? How are we to expect the concerned citizens and the people that are writing the appeal to know that we're gonna fix that? And
Yeah,
you know what I mean? Like this was last May, but there's still things that aren't.
Yeah,
You know what I'm saying?
the
So
problem,
like, when does that
my
stop?
the main problem with this whole entire project is the plans were done so poorly and had so many mistakes in them that it's hard to hold anyone. It's like in either direction, like I'm having a hard time with this because like if these plans were in front of us, we would murder people. It would have been like you would not have let those plans through and I would not have let those plans.
Well,
through.
I mean, we've made requests.
Yeah.
Before we made the decision.
Yeah, and if you don't do it, we're gonna say no, so it's.
Like based on the lack of.
Yeah, based on the lack of plans, we're gonna say no to this, and then all of a sudden, mysteriously, the plans are done perfectly. We've done that, I don't even know how many times we've done this, and that's what's killing me about this whole thing, is that the plans are just not accurate.
I want to throw in two thoughts here. One is that just their nature. Statute of limitations are brutal because they can and they do impact claims that are on the merit, on the actual claim meritorious. You can have a good claim, but it's not going to be heard just because it's too late.
Right.
That is the nature of the beast. Courts enforce them anyway. And for people that are not lawyers, you want to do the right thing.
Yes.
This is a rule that stops. So that's the nature of the beast. The second thing I want you guys really to think about, and the village made this argument. There are some claims under the zoning law that are specific to the plans, as the chair describes, and particularly in this case, the coverage issue is going to be kind of a nuts and bolts thing. But the other claims under the zoning law, not the we can talk about the building code separately, but the zoning law claim, that's where the statute of limitations apply. The primary claim is the definition of family. Okay, and the problem we're facing, and that's not really going to be a plan thing. That's going to be a zoning definitional thing. And the village made the point, and you guys need to think about this because it has ramifications that are very serious. That was a decision that was originally made by the previous CEO before it got to the planning board. That's how it got to the planning board. The CEO had to determine if the zoning was correct before it gets, and the planning board needs to have the zoning packaged for it. And so the zoning was packaged for it. This is an appeal, to the extent it's on that issue, on the exact same issue, as far as I can tell, that Corey was dealing with a year ago. In general, as part of this sort of court brutality on statutes of limitations, that's the sort of thing that is accepted as it's not accepted to go forward with, that they want this brought up originally. And the ramifications here, if it's not, you need to understand. Suppose the CEO makes a zoning determination of X, whatever X is. The project with X has the zoning determination, and it could be a use determination that they've decided to store and not an office or whatever. It goes to the planning board. The planning board spends 5 months reviewing the site plan, issuing site plan approval. It goes back to the building department for a building permit. Building permit gets issued with the exact same zoning determination, X. And now, a year later, they come forward and say, X was wrong. And it's right and Terry has made this argument directly. He says he's appealing under 212.63. He said it any number of times in the 2 months that we've been here. And what he's saying is he wants you to look specifically at the section of the code that deals with building permits and forget about that previous determination that Corey made in order to get it before the planning board. That was not a building permit determination. That was is it the right zoning determination? He's divorcing the two so he can come in now. And you're setting up a situation where if you hear it, you're basically allowing somebody to appeal over a building permit issued on a site plan that was issued based on a zoning determination a year and a half before. And so if you're going to do that, you need to think about it, because I would suggest that that's probably a pretty big deal in terms of the village's ability to administer the zoning law. So that's where that argument that the village, and I don't know if I've mischaracterized it, but to the extent that the village made that argument relating to the statute of limitations on the zoning issues, that's where that comes down. And if you were to come up with, to allow it to go forward, you're setting yourself up for this particular problem where the planning board would be issuing site plan approval and it would be subject to review upon the issuance of the building permit based on. And that's why, this is why we have statutes of limitations. That's why we want this to be done within 60 days of the original determination. I don't want you to decide that now, unless you want to, but that's the way my analysis is. And clearly, to the extent that the appellant has legal counsel, God bless them if they want to come in here and make an argument, make a counter argument. I would love to see it, but that's the way I'm breaking that down for you guys in terms of the statute of limitations on the and I have other points of view on whether you have jurisdiction to hear the building code issue. And if you want to hear that, but again, it's up to you how you want to proceed on all this.
So I just want to make sure I'm understanding, the determination the court made in, it was July of 2023, that
Was it July and March?
March, I don't remember March or July, I didn't see timeline was,
I think what we're talking about is a decision that the existing home is a single family home and that this would be a two family home.
yeah,
Is that right?
so, yeah, it was July of July.
And that's
25th,
functionally what
2023.
what the appellant is contesting with respect to the substance of the zoning decision.
So then it would be 60 days from then.
It was actually March 31st.
Oh, that was, on the one timeline that we have, you have a dated letter from chief code enforcement
There were two-
officer stating
there were two
compliance with local zoning code.
Yeah, there were 2 letters.
Okay. I mean, I don't have, I'm not looking at the letter, I'm looking at the timeline that you provided, and then there it has letter from chief code enforcement officer stating compliance with local zoning code is dated 7/25/23, and May is, March I have here, review, readiness for review. May is site plan application revised, including revised elevation drawings.
If you look up at the, above that application for site plan, that's the letter of determination. Readiness for review.
Okay, I'll look at that in Google,
Yeah.
okay. But either way, that's the argument here, that it's 60 days from that time period, even if you were, that's correct.
We're out of it either, yeah.
And if we wanted to extend that or allow that hearing now.
And I can I'll do some, if you want, I'll do some research. to see
I would like to do
what
some-
authorities you
Yeah.
have to basically waive a statute of limitations. I don't know what the answer is. Again, courts would very, very rarely do it. And I don't know,
I mean, I can see the problem, because the problem is, you would have to, it would be it would be really impossible to build anything. Because if someone could, if you did step A, then step B, then step C, and now you're ready to break ground, and they're like, oh, wait, we want to go back to step A, even though a long time has passed, I can see the problem.
The planning board would just look at it and say, why should we bother?
Yeah.
They want to know what the zoning is gonna be before they move forward. And
Yeah.
One of the reasons why the statute of limitations, it can be brutal, is because there's an interest in finality.
Yeah.
And especially with respect to a village, everything that happens in the village has either a 30, going to court, has either a 30-day or 120-day statute of limitations, which is much shorter than civil litigation. Like if somebody gets hurt, you may have a couple of years to sue over that, but the village, the government wants to know that there's finality so that they can make decisions. And I think therefore respectfully, there's a difference between giving somebody an extra 2 or 3 or 4 days if they didn't hear it or something like that, or their friend, there's some extenuating circumstances, they're in the hospital, they need an extra week. We're talking about here a year and a half and with the planning board, detailed review in between.
Yeah.
I think this is kind of a good example of what we were talking about, where in this case, it's a thing of wanting to do what feels right
Yeah.
to correct the situation and what the law is.
Yeah, we don't have a vehicle for that, but I mean, I would be appreciative if you could get us some sort of case law to look.
In terms of the ability of
Yes.
the
Yeah.
ZBA to extend.
I don't see how it could work. I really.
I don't either, but I want to be
It
able
feels
to
right, but it's like,
having the.
I can just see the anarchy it would cause. It would just be complete craziness.
It feels right to be on a particular
Yeah.
thing, the general rules, yeah, it's a different
I
situation.
mean, imagine we made a decision and then as soon as you made a decision, someone's like, oh, I want to talk about one of the other things that happened 2 years ago. We'd be like, I can see why it
That's
would
why
be.
God created sections.
Yeah,
As frustrating as they can be.
Yes, I understand it now.
And that's all the fact in that same case where we have to follow the law.
Yeah, that's not a good job.
Yeah.
And so that, if you.
Yeah.
Depending on what you would decide on that, that would essentially, as a procedural matter, as a jurisdictional matter, take care of the claims under the zoning law. So, particularly the use claim, particularly the family claim, it just would not be properly before you. As frustrating as that might be, and as much as you'd want to address it, it's just not for you because it was done again, a year and a half ago. That, whatever I just said, has nothing to do with on the building side.
I mean,
About that too.
I have mixed feelings about it because wanting to make sure that somebody is getting like the case us to look at whatever, like that's why we're here, is to look at things that people in problem, that's why they were appealed. But also that party specifically pointed out rather harshly that it is my job to follow the law and not alter it.
And again, it's different than if it's a week and a year.
Yeah, of course,
And that's where that.
Yeah, no, I mean, again, we're talking over a year, and I just would like to have some sort of,
Plus,
some sort of.
I will get on,
Yeah,
I'll get on,
sure, so
I'll get you guys a memo on that.
Plus, I assume. Also, the planning board was made aware of all this.
Planning board got the memo from Cory.
Yeah, I mean,
They
so the
operated.
planning board knew about this, and so.
Well, it's not their job is not to, they cannot actually question the zoning. They take the zoning determination from the CEO as sometimes filtered through you on an appeal or even on a variance. A variance fundamentally changes the zoning for this particular applicant, or an appeal, which would have happened then, you would have made the final decision on the zoning, but obviously unless it went to court, but within the village, and then that would go to the planning board. Then when it gets to them for site plan approval, they've got a zoning determination, in this case on the family, as well as anything else. So that's why I just wanted to point out to you guys in terms of what the ramifications here in this particular appeal. And courts are used to the idea of blaming people even when they're not, even if they didn't know and stuff like that. If there's a loss, somebody's at fault, they got to point a finger, even if sometimes everybody's, I'm talking in a civil situation. Courts do that, and that's one reason why lawyers go crazy, is because anything you might ever do could turn out to be wrong, so you cover your whatever 6 times over, because you don't know what's going to happen when things hit the thing.
Okay. All right, so besides the statute of limitations, what else do we need to know?
Well, there was also a claim, and I'll try to explain this as best I can, that there's a dichotomy between the building code and the zoning code, and you only have authority over the building code, appeals over the building code. And it's a really interesting claim. It's a claim made by the village, again, to dismiss the claims relating to the building code, which is largely the staircase issue. Here's where it comes down, and this is where Emily and I actually disagree. I felt from the beginning, first of all, there's a couple of moving pieces to this. The first thing is that it is definitely true, and some of the cases, plenty of cases say this, but sometimes folks in the village's situation rely on it, and I believe wrongly, that this board would have no jurisdiction over a petition for a variance from the building code. You could not issue a variance from the building code. That would have to go to that state body that was described. That I think Mike or Alex described it. However, a variance is not the same as an appeal. And we can circle back to why, but appeals are more complicated. And the question before us is whether, there's 2 questions actually. One is whether this board could hear an appeal from a determination by the CEO under the building code, not a variance, an appeal. And secondly, even if the answer is no, that you cannot hear an appeal under the building code, the really interesting follow-up question is whether the section that the appellant has described numerous times, 212-63C, does something that lawyers call incorporate by reference this other code, the state building code, into our zoning code. That's a kind of what incorporation by reference means is I I could have authority in the village to only look at certain things. Let's just say I can only look at zoning. But as one of my zoning laws, I say every permit that the planning board issues must comply with the Clean Water, the Federal Clean Water Act as administered by DEC's speedies on stormwater. Those stormwater rules are state rules and federal rules. But almost every time the planning board looks at a project under the zoning code, site plan approvals, they're gonna look at that, right? And it actually gets written into every site plan approval, that you must comply with the stormwater rules. Now, that is an example of what I would call incorporation by reference. The stormwater rules are not, this is actually NIMS 4, but that's another story. Basically, there are codes that are not in the village code that we still look at, that we require Alex to look at, that we require the planning board to look at because they're incorporated by reference. And in this section that Terry has cited numerous times, it actually says in order to write a building permit, Alex has to make sure that the building code is complied with and the zoning code. And that provision is in the zoning code. It is 212-63, it's in your zoning code. And so the argument then becomes, this becomes, I can understand why you might get busy about this, it's a bunch of lawyers' words, but this is what this argument devolves into. Does the inclusion of that requirement in the zoning code mean that they can appeal this to you as a matter of the zoning code, not as a matter of the building code? Because when Alex writes a building permit, he's following both the building code in the village's building code, section, chapter 83, and also chapter 212. Now that's where, this is what Emily and I disagreed on, okay?
I do have a question in the documentation that we was provided. And I know you have it right there. One of the things that I know, fourth paragraph, it talks about what you're saying, appeals. Fourth paragraph, it talks about appeals.
Exactly right.
And in there it says, or any other entity granted such authority by local law, orders, regulation. Isn't that what the ZBA is? For an appeal purpose.
That's right.
And then it says, in contrast, so it's saying something completely different.
Exactly right place.
Okay.
And I will, that's exactly, that's actually, I think, what the conclusive answer is. So the question was, this is, and Emily went ahead and she got some cases and we discussed it, and that was a situation essentially up until today. And today we got the submittal from the village, and the village does include, this is Exhibit E. And it is a publication by an office in the Department of State called, I believe, the Building Standards and Codes Office. And they explain about appeals and variances relating to building permits discussions, building permits application of the building code. So this is the State Department of State, which administers this program, telling us how this should go. And the third paragraph talks about variances, and it says flat out, you don't have any authority to grant variances. Simple, that's what I said before. And let's read the first two sentences of the fourth paragraph. And again, this is what was submitted last night by the village. Appeals of an order or determination of an administrative official charged to enforce or purporting to enforce the uniform code, meaning the building code, can be heard by the regional boards of review, that's that state board that we're talking about, or any other entity granted such authority by local law, ordinance, regulation, etc. Second sentence. Please note, although other entities can hear appeals of orders and determinations of the uniform code, they cannot grant variances from the uniform code. So, look, that clearly makes a distinction between variances and appeals, and what it says is, if your local code grants you the authority to hear appeals from the building code, you can do it. And this is the state telling you that under this program. Then the only question before us is, does the code grant us that authority? And so with that in mind, we go back to 212-63C, where it tells the CEO to make sure he's considering the building code as a matter of the zoning law in writing a permit, And the most critical section, which I don't have in front of me right now, is the one that grants you the authority to hear appeals from Alex's orders under the zoning code. Again, to me, this just reinforced my earlier determination that the appeal was valid. Emily was originally starting out disagreeing with me, and she thought it was not valid, but after I shared this with her today, she came around. Again, that's just, you guys will be the decision maker on that, but that's what we have before us. And I can go into some more detail as to why even my original instinct was that the appeal should be heard, because, and what it comes down to is this, and this is why I said that sometimes opinion becomes important. There are times in legal interpretation when the words of the law does not necessarily lead you specifically to an answer, when there's discretion in figuring out what it means. And when that happens, courts do things like look at what, the intent of the law, but on a federal level, it's congressional intent and all the words that come out in hearings. And when I thought about what the intent of this particular type of dichotomy was, and I thought about it at some length, I also determined that the policies behind it did also lean in favor of the board's jurisdiction. I think, and again, I want to be totally fair, I mean, she's not here now, and I'm just sort of reading into it. There is, and I think where the village was, there is sort of the instinctive determination that the policy should be against it, that there's something completely, not sacrosanct, but that the building code is a matter of public safety, and therefore this board should defer to this set of state experts. And that's pretty fair interpretation for starters, but I thought there were other policies that weighed against it. And I think that this interpretation backs that up, because the state seems to be okay with this board doing it as long as you have that authority granted to you by the local code. And I can explain to you why, if it's of use to you, why I think that there are countervailing considerations other than this one idea that, that this public, you shouldn't even touch this public safety code. I think there are countervailing policies that would lead you to state jurisdiction. So overall, I would come down, if you want, how much detail you want to hear, I would, if it were me, I would exercise jurisdiction over and again, this document I think is an important one, and as I analyze the policies, I also think it's important. So that's where that is, and I'm happy to either give you more detail or what type of information you want. You're welcome to the world of lawyers.
Yeah, I was confused, now I'm more confused, okay.
So initially, there's two decisions to be made, and then underneath those, there's several.
Those are called, what we call jurisdictional decisions as to whether you can even proceed. And then underneath, then if you jump through that hoop, then there's the real questions, yes.
Okay. But let me ask a really fast question.
Okay.
If we were to rule on the timeline, how much would that mean most of this, would that eliminate some other decisions we have to make?
It would eliminate the substantive decisions under the zoning code, which the front and center, that would be the family sets of issues.
Okay.
And then secondarily, depending on the specifics here, I'd want to understand the specifics a little more. It might eliminate the site coverage issues.
Okay. So, all right, so I think we should,
Real quick, I just want to make sure I understand what would happen here. If we were to come to a conclusion that the timeline is to be followed and that it's the 60 days stands, and we're not like trying to override that in any way, then defining a family is no longer valid.
Listen, you don't even have jurisdiction over it. You do not have, literally, you don't have jurisdiction to just, and that's again why the statute of limitation is so frustrating, because it doesn't let you get it.
Yeah.
That's the way.
Right.
That's the way it works.
Do we have to make it, I'm reticent to make a decision on that tonight without.
I'm ready to make any
You
decisions
should,
tonight.
I mean, Terry may well want to.
Yeah, I'm very hesitant to make any decisions tonight.
He only got this 24 hours ago, so,
There's some.
he doesn't
no.
have the chance. to
I mean, that's why we're postponing.
Yeah,
That's
no,
why
I
there's-
just, when you said that, I wasn't sure we were gonna make a determination tonight.
That's what's up to you, but I would.
I mean, as much as I would like to do that, I think I need to read this document and with a lot of coffee in me. And like an aggressive amount of coffee, because it's making me, my head.
Which document are you from?
All of them. All of them, they're all 120 pages we got today.
Plus, we're
Um,
Plus,
Okay,
yeah,
all right, so I think we all agree that this is, all right, so is there any other? Sorry. I'm like, this is really, I'm asking the lawyer if he wants to talk while he's being paid by the hour.
I'm just getting started.
Oh.
I would suggest one other thing, which I mentioned before, if the board would think about setting a procedure or time frame so that everybody can submit whatever further comments they want.
Yeah, we need clarity.
Okay, all right. So, okay, so the timelines, I was thinking about this, if we said 2 weeks before if we said written,
That's a normal thing.
written, everything written has to be in 2 weeks before the meeting?
Entirely reasonable.
Okay, so the meeting is what, October?
That's like.
Yeah, I mean, our next meeting, that's hopefully, so, right, so we're at the end of this month, so.
comfortable with 1 week.
That would be next Tuesday.
Tuesday
Yeah.
before. So, yeah, that 2 weeks would be.
Should we postpone this to the November?
All right, so, but the meeting is October
Eight.
8th.
So look for.
Would October 5th?
You're giving yourself 3 days to read it all,
Well, the first would be a week.
First, yeah, okay, October 1st. October 1st?
and today's what, the 20th?
First is fine.
Today's the 19th.
Yeah,
We get a-
we're splitting it in their favor.
Yeah,
That gives us 12 days to.
Well, I mean, we have.
I'm from October 5th.
And
yeah, October 5th is bad. I
Actually,
just picked that. It's my birthday, that's why I picked that. Okay.
You wanna read a bunch of legal documents?
No, I'm just trying to pick a date between it.
Is October
Is that
1st,
comfortable with you, October 1st?
October 1st, you respond already? You would, the board is proposing to give you till October 1st to respond to the written submittals in writing. And you still. Respond to anything you want.
So what you got?
Also, what I said, which is important to you, I was talking about the statute of limitations. You may want to respond to that as well in writing. You have the opportunity. But October 1st, so it'll be 11 days from, 13 days from now.
Yeah, so you want to reply by the first.
If you choose to write something.
Yeah, okay.
Have it in by October 1st. In any event, you can come next month and speak as much as you want, but if you want us to write down cases or whatever, October 1st.
Can I have a copy of that, that you mentioned from the.
You have it, it's exhibit E.
In my packet, but we said that.
There it is. Exhibit E. E, elephant.
Letter E, it's letter E in our backup information.
And I.
You want my copy? It's got my highlights in there.
We're just trying to.
But it's-
Something or something.
The reality is, yeah, you need some sort of clarity and the only thing you can do, but.
Yeah. Is the village going to be able to respond with all the?
We can
regular
make
stuff?
that October 1st. We
Okay,
can make
good.
that.
All right, cool. All right.
With you guys, good.
I mean, with it
Is there any
being,
benefit?
with it being a short break,
Meeting, so.
or greater,
Or
out there, you're gonna.
But
I think
fair.
I think October, I think by next meeting, we've been at this for 3 months now.
No.
So I'm just,
Bear in mind, you're holding the public hearing open, so you're gonna
Yeah.
get new comments, so I don't
they
think
can
any
do
of
it
us are expecting a decision on the 8th.
Almost 3 weeks.
Or the board might choose to do jurisdictional decisions and now at least now the thing and, you know,
Yeah.
whatever you guys want, whatever you guys feel comfortable with. So
Yeah.
Well, so like Steve was saying before, essentially it's two sets of columns that are in two different boxes. So if we rule on one of those, it takes us either where we have to now still make 4 decisions or 2 or.
it gets to what lawyers call is the real, lawyers have a lot of procedural gobbledygook that before we even get to the real question, which is why people hate lawyers, because people like to get to the real question, but the procedural issues were raised by the village. It wasn't the lawyer that raised it, although we were aware of it, it was them. So they're making the claim, they made the claim basically tonight, translated, you can't hear any of this. They said, you can't hear the zoning decisions because it's time barred, you can't hear the building code decisions, because that's for the state, you can't touch that. They told you tonight, you cannot hear any of this. And so you may want to decide that before you get into the things that they're telling you can't decide.
John, you do need to do a motion for that October first, if that's what you wanna do.
Okay, all right, so I'd like to have a motion that all paperwork in relationship to 7 prospects will be handed in by October 1st. A motion. Second. Vote. Aye, 100% on that. I think I also am going to motion to finish the meeting. So we can all research and aggressively read all this paperwork. I have a motion to end the meeting. Second. Okay, all in favor? Aye, okay, looking over, TV.